Hello, I'm VA-Accredited Claims Agent John Kent, here with VA-Accredited Attorney and Partner Jonathan Greene, and today we'll talk about supplemental claims and new and relevant evidence. So John, when we receive a rating decision from VA, there's a couple different things that you can do after you see that rating decision. Can you just briefly touch on them?
Yeah, sure. So within 1 year of the date of that rating decision, if you disagree with something, you can file a number of appeals in a few different ways. One is you can file an appeal in what's called the higher level review lane, and that's basically just saying that VA got something wrong and based on the evidence already of record. Another option is to file a notice of disagreement, which is an appeal to the Board of Veterans' Appeals. A third option is to file what's called a supplemental claim appeal, and that's what we're discussing today.
Absolutely. So yeah, for the purpose of this video, we'll be getting into more depth on supplemental claims for VA. So when you do want to file a supplemental claim, you are filing that on the VA Form 20-0995. What are some of the information, some of the requirements that you need if you want to file a supplemental claim?
So, as I mentioned, one of the other options is the higher level review option. That is an appeal you're filing without any additional evidence. This is the appellate option that you file when you feel that additional evidence is necessary to persuade VA that a benefit should be granted. And the evidence needs to be both new and relevant. And new means not already of record, and relevant means tending to prove or disprove a matter pertinent to the claim.
Yeah, exactly, absolutely. So when you are getting into that new and relevant evidence, as John mentioned, new not being part of the record previously, relevant, tending to prove or disprove a matter at hand. What are some of the examples of evidence that you can submit to fulfill that new and relevant evidence requirement?
So it obviously depends on what VA had previously denied, what's the issue, and what are you trying to prove. A lot of times in our supplemental claim appeals, we'll submit a statement that is provided by the veteran or possibly somebody else, what we would call a buddy statement, and clarifying a point, providing some testimony about the severity of symptoms or about an incident that happened in service. And we submit that, something that is new, not previously of record, and relevant, tending to prove or disprove a matter at hand. So something else could be updated treatment records, private or VA treatment records. Certain VA forms would be considered new and relevant evidence. So medical authorization forms, the 4142s, a statement can be written on the 4138, and we also will submit applications for the unemployability benefit, the 21-8940, as new and relevant evidence sufficient to satisfy that requirement for a supplemental claim.
So there's a lot of options we're hearing about new and relevant evidence that can be submitted to help fulfill that requirement for a supplemental claim.
And one other important one that we do often submit is independent medical opinions, independent expert opinions. So vocational expert opinions, medical expert opinions. That's the real good stuff that is going to show that an expert finds whatever the issue is sufficient for a supplemental claim.
That's a great piece of information to have associated with your supplemental claim if you can obtain it. So there's a lot of different options that you can submit that will fulfill that new and relevant evidence requirement for VA. What are some of the advantages of going the supplemental claim route if you want to file an appeal for your case?
So, in some of the other options, namely the higher level review, it's a closed record, so nothing new can come in. So a lot of times additional evidence is going to support the case and bolster whatever claim that was denied. So you're allowed to provide new evidence. The record is open. Additionally, VA is then also sort of in a position to develop the record themselves, so they can find that additional evidence is necessary. They don't need to issue a final decision on that closed record. They can do things to do their own development, hopefully development that will result in evidence that will win the case.
Absolutely. If you do have any questions, if there is any assistance you're looking for in filing your VA disability claim, please reach out to our office, either at the information below or any of our social medias. Thank you.
Thank you.